Shmai, hello Shmai. We've done some training with you as well in the past, I think. Good. So in terms of the Renting Homes Wales Act, does anyone have any knowledge about it at all yet? Some of you definitely will, but some of you may not. Everyone all right, reasonably? How are we feeling on it? Like, do you know it? Ask you, what does Section 81 mean? What does Section 55 mean? So we'll have a look. I'll go over the basics again, just for everyone to sort of understand. We'll have a look at standard contracts, the grounds of possession. Mainly where I want to concentrate on is Section 173 notices. So these are what used to be called Section 21 notices. Everyone remember those? Arose by any other name. They are now called Section 173 notices, all right? They are landlord notices. So they still exist, unfortunately, no-fault notices. So I want to have a brief look at those, and we will look at what we can do when we're helping, just to see what could be challengeable. What does a landlord have to do to make sure that a no-fault notice is valid these days? The answer is a lot more than they used to have to do. The landlords used to have to do. So there's a lot more in there. So we'll have a look at those. So basically, just to get the basics out of the way, on the 1st of December 2022, that's when renting changed for everyone in Wales, almost every tenant and landlord in Wales. So if you don't know, I don't know where you've been, but it's been in place since the 1st of December 2022. So we're past the 6-month point. It's called the information provision period. The information provisionary period basically gave landlords, local authorities, the time to be able to send out new contracts. All new contracts should have been sent out to contract holders in private accommodation and in the community side of things as well. If they haven't been received by now, so that's the 1st of June, what are we at? What date is it today? 2023, but what's the date today? What are we at? Yeah, so for every day that the contract is late past the 1st of June, landlords may be liable to pay compensation equivalent to a day's rent for each day that the contract is late. Now, that's really, really interesting. Now, what the Act states is that's almost strict liability. So that means you make an application to the court, and you have to make an application to the court for compensation, and you can prove that your contract is late, the court will say, yes, absolutely. There's 2 weeks worth of rent. There's 3 weeks worth of rent, blah, 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 whatever. If the court finds that the landlord has deliberately not sent out a contract, they can award double the compensation. Okay, so the way it works is the Act states that you can get compensation up to 2 months. Right, so if you're 2 months late with a contract, it's up to 2 months. After that, the court can award more compensation if it wants. It's up to them. Okay, so we're yet to see. I don't know if anyone's put any of these through. Anyone seen any of these yet? We might start to see them coming through as this progresses. But we're past this date now. So before we understand what a contract is, first we have to understand what isn't a contract. So I know it seems like a bit of a weird way of doing it, but we have to sort of go, right, what isn't a contract before we understand what is an occupation contract. So an excluded agreement, aka what we used to know as a license. All right, everyone all right with that sort of terminology? Do you remember what used to be a license? Now called an excluded agreement. All right, so if the proposed contract holder is under the age of 18, it is not a contract. You cannot hold a contract under the new Renting Homes Wales Act if you are under 18. All right. As soon as you turn 18, then what will happen is the landlord should consider whether you might be owed a contract. All right. So if someone's in supported accommodation, for example, they turn 18 in that supported accommodation, then it'll be up to the landlord in that circumstance to say, right, does this person need a contract of some sort? Okay. You have to be an individual in order for the contracts to be in place. So it can't be a company. All right. You've got to be an individual person. Okay. So it's an individual person contracting with a landlord. Or you can't be a company. It has to be an individual person. Where rent is not payable, if you're not paying rent for your property to your landlord, then technically, obviously, it's not a contract. You could be paying rent or other consideration, though. Other consideration could be where someone's moved into a property and they're doing it up. All right. And instead of paying rent, they're doing it up for the landlord. All right. So that could be other consideration. But otherwise, it is not. That is not rent. Oh, that is rent. Sorry. Yeah. It's other consideration. So it's what the Act states is rent or other consideration. Other consideration might be that circumstance. Okay. Anyone, so holiday lets, not an, so anyone in an Airbnb, obviously is not an occupation contract, right? Any type of holiday let. Care institution, not an occupation contract. Temporary expedience is just a posh name for sofa surfing. It's just what the Act is called, sofa surfing now. Okay, so you're staying with someone for a short amount of time. That is not a contract. Okay, it's temporary expedience. Shared accommodation is defined in the Act as accommodation shared between a landlord and an individual. So if you've got a lodger as a landlord, it is an excluded agreement. It's not an occupation contract. Yeah. Yeah.
The care home setup that were historically on assured agreements.
Yeah.
So come December the 1st, they automatically converted.
Yeah.
So they've got them.
Yeah.
But you said
it's not, but if they're in that circumstance and they previously held an assured tenancy or a secure tenancy, they would convert probably to a secure contract, I would imagine. That's going to depend on the circumstances. It's excluded, but historically, I would say that if they've had a tenancy and held a tenancy, they will convert. So it can be excluded. I wouldn't imagine that many care institutions wouldn't convert them over though in that circumstance. But you know, we'll wait and see. Each to their own. This casework malarkey can be crazy sometimes. Business tenancies under the Landlord and Tenant Act 1954. Good old Landlord and Tenant Act 1954. That kind of tenancy is not an occupation contract. The 1977 Rent Act tenancies. Now, these are, I came across a few of these when I was a caseworker, but not very often. Basically, anyone who moved into their property, all right, and held a tenancy prior to 1991, essentially, right, they'd have what's called a Rent Act tenancy. All right. Now, if you're in that circumstance, you haven't got an occupation contract, but technically you've got security of tenure under the other act. All right. So you're still protected, but you haven't got an occupation contract under the new Renting Homes Wales Act. Armed Forces accommodation, they sort of work under their own rules. So anyone who's in the armed forces, they're given accommodation tied to their work in the armed forces in barracks. So when someone leaves the armed forces, what's meant to happen is the army's meant to notify the local authority. Doesn't always happen. That's what should happen. Okay. Direct access accommodation is defined in the Act as accommodation that's given for 24 hours or less at a time. Right. So certain landlords or charities who provide accommodation for 24 hours or less at a time, it is not an occupation contract. Okay. It is an excluded agreement, a license. And then this part of the Act is really interesting. Accommodation under homeless duties is not an occupation contract unless the local authorities accepted a Section 75 duty. Now, this is where the Act gets a little bit confusing. So basically, if someone's in temporary accommodation that's supplied by the local authority, they run it. Okay, it is not an occupation contract until they've been given a final homeless duty, a Section 75 final homeless duty. It's a little bit complicated because what the Welsh Government has done is they've not exactly made it very clear that there is an interaction between the Housing Wales Act, which is homelessness law, and this new Renting Homes Wales Act. All right, it's sort of collided, and they haven't gone out of their way to say, oh, by the way, this happens. So we have to notify everyone. We're trying to tell everyone, right, this is what this means. Basically, don't worry too much about this unless someone has a question on it. When it comes to temporary accommodation like hotel or B&B accommodation, what the Welsh Government is, they've opened up a thing on that at the moment where they're waiting to hear back on local authorities. That type of accommodation is going to be excluded from the rule regarding occupation contracts anyway. So we're probably going to hear in a couple of months' time that the Welsh Government has taken out hotel and B&B accommodation from the temporary accommodation definition, which means that occupation contracts never become owed in those circumstances. So yeah, So you can basically, I can tell you about it so you can forget about it, essentially, okay? Because we should be getting some of that reasonably soon. Supported accommodation. Does anyone work in supported accommodation or has clients in supported accommodation? So anyone who's in supported accommodation, the landlord basically, for the first 6 months, someone is there. It is a license, okay, a license agreement. Unless that license agreement is extended by 3 months at a time, is extendable by 3 months at a time, then it becomes what's called a supported standard contract, a type of standard contract. But basically, in supported accommodation, it's essentially a license for the first 6 months. And just remember, someone could turn 18 when they're in supported accommodation, and they might have been in there for longer than 6 months. So our interpretation of it, Mark, would be that once they turn 18, that the supported accommodation provider should consider giving them a supported standard contract if they've been there longer than 6 months, right?
Choose from the start.
Yeah, absolutely. Yeah, very good point. Thank you very much. It's a great point, actually. You can, in supported accommodation, the landlord could choose right from the outset to give a supported standard contract. So to give that young person, for example, a lot more security of tenure if they want to. Obviously, it's going to be different. I don't know how the different local authorities are going to deal with it. But obviously that is something that can happen. Okay, everyone with me still? Sort of? Yeah, not falling asleep yet? So no more social landlords. All right, they are now called community landlords, not quite no more social landlords. So community landlords are basically councils, local authorities, RSLs, registered social landlords, or private registered providers of social housing. PRPSH. I'm going to say that. No, PRPSH. And then everyone else is a private landlord. All right, is the idea. So not a huge change in the definition. What is different is the terminology. All right, so community landlords and private landlords. So just keep those in your brain. No more tenants, not quite. All right, they are now called contract holders. So anyone who rents in Wales is now a contract holder. Yeah, so you can still be called a tenant, no problem. But legally speaking, when you're looking at the Act, you are now a contract holder, okay? Because you've got to be given a hard copy of your contract. It means that hopefully, before you move in, you're aware of your situation, you're aware of your circumstances. The contracts are meant to be written in more plain English. I don't know, maybe. They're still quite long. You're still talking about 40 or 50 pages. But the idea is that because you get given a hard copy of your contract from the start, you can see what your position is. So you can see, right, if I fall behind in my rent, this is what's going to happen. All right, if there's antisocial behavior, this is what's going to happen. I do think the contracts are better for advisors, for anyone who's advising, who has clients in those circumstances, because we can explain it a bit better. Right? It means we can understand it a bit better, I think. But they do take a little bit of getting used to. So two main types of contracts, everyone. Okay, under the Renting Homes Wales Act, you will have standard contracts with private landlords. So think private landlords, think standard contracts. All right. So anyone in the private sector, essentially, they're going to be given a standard contract. Although interestingly, a private landlord could give out a secure contract if they wanted to, but why on earth would they do that? It's a terrible idea for them. So the private, so the standard contract, much like the old system. Does everyone remember the old assured short-hold tenancies? The joy of the assured short-hold tenancies, remember those? Same system now, all right? So you can be either fixed term for a set period of time, so say 6 months or 12 months, or it can be periodic, it can be month to month. Right? It's up to the landlord what they want to use, really. We think that landlords, private landlords, are probably predominantly going to use periodic month-to-month contracts from the start. It makes a lot more sense for them, private landlords, to do that. It means they can regain possession if they need to quicker, and it means they don't have to give out another contract. If a landlord does give out a fixed term contract, then that fixed term contract could look ahead to the rolling phase, the periodic phase. You just need to stick a term in the contract, basically. Now, with these standard contracts, okay, the big new change, landlords cannot issue a no-fault notice in the first 6 months. So under the old AST system, right, if I was in a property with a private landlord, a lot of the time what landlords used to do would be to give out a Section 21 notice, a no-fault notice, when you signed up for the property. So basically, they could chuck you out if it didn't go well for whatever reason. You know, they didn't need a reason, really. That's why it's called the no-fault notice. Now, landlords cannot use a no-fault notice in the first 6 months. And that notice has to be a 6-month notice. So what that means is, essentially, you will be getting a guaranteed 12 months in your property, as long as, obviously, there's no issues with antisocial behavior, rent arrears, or any other contract breach. Okay, but when it comes to no fault, you're looking at a guaranteed 12 months. So this 6 months notice is standard, bit different for people who converted over, who already were in some kind of tenancy on the 1st of December 2022. Basically, it was 2 months notice up until June, and then it flicks to 6 months notice. That's going to be fun for local authorities to deal with over the next couple of months, I think, because we're going to start to see the end of 2-month notices and 6-month notices as standard. But, you know, we argued we wanted to get rid of no-fault notices. We're not quite there, but 6 months is pretty good, I think, generally. You know, gives people a bit more time in their properties. So once that, and I'll get on to the Section 173 notices later. Yeah, the right to vary contract terms, basically landlords can change the terms of the contract you've been given as long as they give you notice that they're going to change those terms. Right? You can't just sort of go and change any term you want in the contract, okay? Because the terms now have been graded in terms of their importance. You can't just go, oh, right, well, I'm going to take that out because I don't like you. Landlords must notify the individual using the correct notice if they do want to change a term. And I would say that if a landlord does have a go and wants to try and change a term themselves, they're going to find it a bit difficult. You're going to need expert legal advice to change a term in a contract. All right, so if you do and are helping anyone who has been given a contract where a landlord has changed a term, just be very careful, all right, because it's highly likely if the landlords try to do it themselves, it's not a good idea. Okay, they need to get expert legal advice for it. Yeah, so the terms have been graded in terms of their importance. So you've got at the top fundamental terms, which can never be changed. Okay, they've got to be included in the contract as they've been written. They can't be altered at all. Then you've got supplementary terms underneath those, which can be changed as long as both parties agree, which is quite an interesting little bit of the act, that. So you've got essentially certain terms you can change, certain terms you can't, all right? But you will need legal advice on it because it's very complicated. And again, if a landlord changes a term incorrectly, there's the option for a contract holder to be able to apply to the court for a determination on the contract and compensation potentially as well. Right, so this act, basically, if you think about it now, the way things have changed, it's all about contract is king now, okay? I think you've all got mobile phone contracts, I presume, of some description. I've never read it. Has anyone ever read it? No. But if anything happens with your mobile phone contract, with your mobile phone, you can go back to your contract and it'll look after you, basically. If you don't have any signal for 2 or 3 days, then you can claim according to your contract. Okay, it's a consumer protection approach. This is what this new act is about. It's about making sure that people are protected. You're protected in the Consumer Rights Act, essentially, with this new legislation, okay, as well as the act itself. So it's a step in the right direction. Fitness for human habitation requirements. Basically, you've got to make sure that your property is fit for human habitation. Landlords have to make sure it's up to a certain standard on the day someone moves in and for the duration of the contract. Right, that's going to mean smoke alarms, carbon monoxide alarms, smoke alarms connected to the mains, for example, EPCs, electrical condition reports, gas safety certificates, the list goes on. All right, so with converted contracts, landlords have got up until the 1st of December this year But for all new contracts, it's got to be sorted out as soon as someone moves in. Okay, so if you break as a landlord a fitness for human habitation term, then you may be liable again for compensation. Fitness for human habitation is an interesting one. I think it's a bit toothless generally, my personal opinion, that part of the act. But yeah, succession rights and transfer. Basically, even with this private contracts now, standard contracts, you could pass on the contract to a partner. So say that someone dies in a property, that contract could be passed on to a partner, all right, and they could then take over the property, take over the contract, right? Similar thing for secure contracts as well. Yeah, the big one for standard contracts, right, is if you're in a standard contract, you are 2 months or 8 weeks in rent arrears. What the landlord could do in that circumstance is take you to court. And if you are still 2 months or 8 weeks in rent arrears by the time the claim is heard by the court, it is a mandatory ground for possession. The court must grant possession. They've got no choice. But our interpretation would be that if you bring that down below 2 months or 8 weeks by the time the claim is heard, it becomes discretionary. So the court can decide whether to grant possession or not. All right? Everyone with me? Yeah. So say that you're 2 months. So if you, standard contracts only, just standard contract. So everything I'm talking about now, just standard. All right. So not support. Oh yeah, for support is standard as well. Anything with the word standard in it means that the rent arrears rules will apply. So if you are 2 months in rent arrears, if you pay your rent monthly, or 8 weeks in rent arrears, if you pay your rent weekly, and the landlord can issue a rent arrears notice. If you are still in that amount of arrears by the time that the court hears the claim, as in it goes to court and the court puts a hearing in and you're there and doing all that, then the court will have to grant possession to the landlord. You've got no choice. No, you can do that at any point. Yeah, so this 6 months notice is only for no fault, right? It is not for rent arrears. It is not for ASB. All right, so if you are in a position where in the first 6 months of your contract, you are 2 months or 8 weeks in rent arrears, the landlord could issue a rent arrears notice. Similarly, if there's antisocial behavior in that first 6 months, even though you might be in a fixed term contract, the landlord could take action on that basis. A claim for universal credit? I don't know. What's a while, I think. I think you could argue mitigation in court and say that we're waiting on universal credit to pay this and it'll be sorted. And I think the court would listen. Well, exactly. Yeah, it's good, but that's going to come down to the judge on the day, innit? Yeah. Yeah. But I think we'll need case law on it, Jackie, I think, because we'll need that to go through for the judiciary to go, this is what this means.
The action protocol would stop them being allowed to take a matter to court if there was an issue with benefits and they were waiting for benefits. So they wouldn't get to that stage.
Hopefully.
You trust me.
Okay, so everyone clear on that with rent arrears? Now, interestingly, when we look at secure contracts, so think secure contracts, think community landlords. All right, when we look at secure contracts, so community landlords, so sort of housing associations, local authorities and councils, all right? With that sort of situation, there is no ground date. There is no mandatory ground for rent arrears. Technically speaking, someone could be in thousands and thousands and thousands and thousands of pounds worth of debt in a community contract, and it's up to the court to decide. Okay, it's not for the court to say, I must grant possession. The court has discretion. No, exactly. So I think you're right. I suppose all it's done is yeah, I suppose, but what we didn't have before, it was never codified. What we do now is we have it codified. We have it in the law itself, which which is good. Similar powers to vary contracts and vary terms here. Succession rights and transfer. I think this is going to be more pertinent for community side of things. If you say you've got a family now, okay, with a community landlord, you're now going to have two successorships, so a priority successor and a reserve successor. So a priority successor would be a partner or a spouse, okay? And then a reserve successor would either be a resident family member or an unpaid carer. So technically now what could happen is someone dies, okay, that gets passed on to their partner or to their spouse. That partner or spouse can then pass it on one more time, okay, to their resident family member or an unpaid carer. So essentially what you've got is security of tenure for people across generations, as long as obviously that property doesn't become too big for them. All right, if you're under occupying the property, the council can use what's called an estate management ground to get you out, okay, because they needed to give to someone else. But the successorship rights, I think, are a good step forward, certainly to have a second successorship now available, where previously you could only pass on your contract once. So I think that's really good that you think. Yeah, so with a spouse or a partner, it's no time limit, whenever. With a reserve successor, it's meant to be 12 months as a resident family member, but you can take into account the amount of time that person has been there if there have been 2 deaths within a quick period of time. Similarly, for an unpaid carer, again, it should be 12 months. But if you've got nowhere else you're entitled to live at the time that the person dies, then you can take into account the amount of time they've already been there. So essentially, you can take into account the time that the person you're succeeding from has already been in the property, right? If circumstances allow. So if you do, if you're ever supporting someone in this situation, please come to us if you've got questions on it, because it can get quite complicated, this. But I think very good anyway, generally. Alternative standard contracts. I'm not going to spend too long on this. Basically, these are standard contracts that only community landlords can use. So only councils, RSLs. Now, we're calling them alternative standard contracts. They're kind of, remember I talked about standard contracts. So think standard contracts, think private landlord. Now, these are types of standard contract, what used to be called ASTs, that community landlords can give out themselves. An introductory standard contract, basically what used to be known as a starter tenancy, right? So if you were signing up as a young person with a housing association or a council for a property, normally what would happen is that person would have been given a starter tenancy. Similar thing now in place. It is now called an introductory standard contract. What I've heard is, when I've done this across Wales, is a lot of housing associations are phasing this out. They're not going to bother giving someone an introductory standard contract and then giving them a secure contract. They'll just move them straight on to a secure contract. But, you know, I can't speak for all regions of Wales. It's going to be different to wherever you are. It's going to be different with the housing association. A prohibited conduct standard contract, basically, that's where someone's on a secure contract, right? And there's been ASB for whatever reason. And instead of outright possession, that housing association might apply to the court for a prohibited conduct standard contract to get that person demoted down, basically. Okay, so instead of outright possession, they're given this contract instead. And then a supported standard contract, as we mentioned earlier, becomes owed in supported accommodation after 6 months. All right, unless that 6-month period is extended, and it is extendable by 3 months at a time. It's called the exceptional approach to license extension. Supported accommodation providers shouldn't be just extending that license indefinitely, ideally. You can, as if you're in a sort of supported accommodation, if the supported accommodation provider tries to extend your license, you can technically apply to the court, appeal basically, against the decision to extend your license, right? And say, well, actually, I should be given a contract. We'll see. I think it's going to depend on the circumstances as to whether it would be successful or not. So, everyone with me so far? Any questions? No, good. You're not allowed any because we haven't got enough time. How are we doing for time? We're all right, don't we? So Standard contracts, okay, in terms of possession. So what can landlords now use as a possession grounds? In terms of the ones that are similar to secure contracts, Section 157 of the Act, that would be a breach of contract. Now, for example, all right, I would say that could be something like lying on your application to get the contract in the first place. All right, that would technically be a breach of contract. Okay, but it's not an prohibited conduct ground. So that could lead to possession action by the landlord for whatever reason. Yeah. Section 55. Now, Section 55 is antisocial behavior and other prohibited conduct. So it's what we've always known as antisocial behavior. It covers a huge variety of things, as we know. It can cover domestic violence, although you will not see domestic violence mentioned in Section 55 of the Act. The wider definition of domestic violence is in the contracts themselves. So if you breach a prohibited conduct term, antisocial behavior, landlord can issue a Section 55, well, it's not a Section 55 notice, it's an RHW 18. Basically what that would mean is the landlord would issue a notice and they'd be able to start possession proceedings immediately, all right, with this type of prohibited conduct notice. Estate management ground just basically is the landlord's use of their housing stock, right? If a landlord wants to take the building back, for example, they've got a block of flats and they want the block of flats back in order to sort of do the roof or something, then they could use an estate management ground. So estate management grounds are just down to the landlord's use of the housing stock, not down to contract holder conduct. And then a contract holder's notice, if I'm living, if I got a standard contract with my private landlord, I decide I want to leave, I give my landlord a 1 month notice. Okay, if I don't leave at the end of that 1 month, the landlord could, technically speaking, use that notice to enforce against me in court. So basically, a contract holder's notice, a notice I give my landlord now, is binding on me. Okay, it's legally binding. I can't change my mind. Okay, if I do change my mind, the landlord could decide to let me stay. That's fine, but they could, if they wanted to, choose to enforce it against me in court. Now, there's some types of notice, some types of possession grounds you will only see with standard contracts. The biggest one is Section 173. Okay, the landlord's notice. Basically, the landlord's notice is the successor to the Section 21. Everyone remember the old Section 21? Long may it, not be around. So basically, the old Section 21, it's still here. It's now called a no-fault notice, aka a landlord's notice. As I said, remember, with a no-fault notice, you can't use it in the first 6 months as a landlord. You've got to put a 6-month notice period on it. And interestingly, landlords have got to apply within 2 months of the end date of that notice. Right? If they haven't applied to the court within 2 months of the end date on that Section 173, they are prevented then from issuing a further notice for another 6 months. Right? So if a landlord misses a deadline, then technically speaking, you're talking about an extra 10 months if someone's got on a property. Right? Again, as long as there's no issues with antisocial behavior, rent arrears, breach of contract. All right? And then serious rent arrears, as I said, 2 months and 8 weeks. But remember, we can bring those down. If someone gets a serious rent arrears notice and they can bring their arrears down to below 2 months or 8 weeks, all good, I think, because then well, it depends on the judge, again, on the day. But all good, really, if you can bring it down, because then it becomes the court's decision rather than I have to give it, okay? So, yeah. Yeah.
Because there's 2 notices. What would you serve the 2 notices, or could this 173 okay?
You'd have to take some legal advice on it but you can serve, as many notices as you want. There's no prescription in the Act that says you have to just serve one. You can serve, but bearing in mind what.
173, you were issuing rent arrears as well as ASB.
I think Go on, Mark.
I'm butting in, sorry. Because I've had this question before. and
I'll
I
have some
think
water
that
whilst we're doing this.
What the Welsh Government have said about sort of the introduction of this act is that they want landlords to use reasons for getting rid of contract holders. So if there was an issue like rent arrears, they would prefer that we were using rent arrears notices and et cetera, but there's nothing stopping a landlord issuing a notice for rent arrears and issuing a guaranteed no fault eviction notice. But I think that comes down to your company organisation policy as well, and it's definitely something that we as Shelter Cymru would like to see.
No.
But that's the job we do, isn't it? But it could be a notice for that and a notice for that.
It's gonna.
As landlords will, they don't evict for no reason.
Yeah.
Exactly. It's quicker to do one with a reason now than it is to do a no fault eviction notice.
Yeah.
And it's a lot less attractive.
Bearing in mind, we're talking about discretionary grounds or compulsory grounds and I think that's what it's going to come down to. You know, your solicitor is always going to tell you go for this one because you're guaranteed to get someone sort of to get possession then, aren't you? So say it again. Yeah. Yeah, so I think we are interested in this because I don't know what local authorities are going to do. I think they might say they can't say come back. I think they might say right, they'll have to take the assessment, maybe take a prevention duty up until what 56 days and then go from there. Yeah. Yeah. So they might not. So they might say, "Don't you're not with it. You're not threatened by homelessness." Yes. Yeah.
You know, as well, can I just ask really quickly on what you said?
Yeah.
So what's your take on use or lose it 2 months expires?
Yeah.
Does that mean our section 66 ends because there's no longer a threat of homelessness?
And I knew I'd get awkward questions. Yeah. 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 I think, as I said, but I think in terms of homelessness law, it's all about evidencing. If you can evidence that the duty is ended, you've gone through what you need to go through, then I can't see there's much we could do in terms of ending duty. Morally tricky, yeah. Yeah. No.
Okay, I mean, if we're taking
this is why this is my problem. This is the issue, is that I don't think the Welsh Government has thought about the interaction between the Renting Homes Wales Act and the Housing Wales Act, and there's a real problem here. So this is something we're gonna need to get direction on from the Welsh Government and from the judiciary as well, because we haven't got a clue. Yeah.
Because they know that means right. So that's next. That's 50%. Okay. So if we're placing them on 70% authority, we look at the individual state who took that 66 duty. The time's ticking.
Yeah. It's I don't know. It's just what we're talking about, everyone here, is we're talking about the homelessness. What happens if you're given a notice? That basically means under the old situation, if you were given a Section 21 notice, you could essentially take that to the local authority, and they would have to take a homeless assessment, and they would probably have to help you. Now, because you got a 6-month notice on these no faults, it makes it very tricky for local authorities in terms of where they're picking up duty, and if a landlord doesn't go to court, what does that mean to a homeless duty that's been ended? Question is, I don't know, and it's down to an individual basis, isn't it? Going to come down to on a case-by-case basis. Yeah, and again, all I can do is just show you the law and just say this is what it is, and until we get direction from the Welsh Government, then unfortunately there's nothing we can do about it. Thank you. 11. All right. Good. So section 173 is basically, am I going to bother with this? So section 173 is it's a 6-month notice. You can't use a notice for the first 6 months, and then it's a 6-month notice period afterwards. Right, as we know, you've got to basically go to court within 2 months of the expiry date on the notice. This is what the notice looks like now. Okay, these new RSW16s, RSW17s for anyone who was converting over. Now, there are things the landlord has to do in order for the notice to be valid. Okay, these are called statutory obligations, things that a landlord has to do. This is not like finicky little things. It's a legal necessity. All right. So a landlord has to provide a hard copy of the contract. You got to give someone a hard copy of the contract now. All right. Unless both parties agree, in which case you can send it electronically. But a hard copy, if that's not been sent, not a valid notice. Has the landlord provided information? Have they provided an address to which documents can be sent on the contract? Has the landlord provided a valid energy performance certificate? Has the landlord protected the security deposit? Has the landlord charged a band letting fee? Are there working smoke alarms at the property that are connected to the mains? Are there carbon monoxide alarms where they're needed there? Is there an electrical condition report? Is there a gas safety report? Now, and also Rent Smart Wales registration and licensing rules are still exactly the same. So eventually, basically, what it means is we're going to be able to look at a notice and go, well, hang on, this person never got a gas safety certificate. That means this notice is invalid. Or there's no smoke alarm at the property connected to the mains. This notice is invalid. Okay, it's all on the front of the notice. Okay, so we can eventually just go through it and do those. Time restrictions. As I said, 6 months and 6 months for no fault notices. And then you're not allowed to serve, this is really important, you're not allowed to serve another section 173 notice till 6 months after the first notice is withdrawn or expires. So you got 2 months, landlord has got 2 months at the end of the notice to apply to court. If they haven't applied to court by that 2-month period, then basically they can't issue another one for another 6 months. Okay, really, really important that. Retaliatory evictions, basically, you cannot now as a landlord, we used to be able to, if I ask you to fix, not you specifically, I don't know if you're a landlord or not, if I ask my landlord to fix something at the property, instead of fixing it, my landlord says, well, I don't want to fix it, it's too expensive. They give me a no-fault notice, right? I can then say to the court, well, hang on, I asked my landlord to fix the boiler. That's the reason. And they've given me this notice because they don't want to fix the boiler. That would be a defense in court. It essentially makes the no-fault notice a discretionary ground. You can argue the landlord has only given you a no-fault notice because they are refusing, terrible landlord you, refusing to fix something in the property. Okay, so you have a defense there now. I'm not going to spend too much on those. And on that one, yeah, and on that one, I'm not going to spend too much on those. So basically, in terms of the notices themselves, when they've been given the no-fault notices, is the notice valid? Okay, remember those information restrictions, the statutory obligations. Is everything on there? Has the landlord done all of those things? There's quite a lot of things. Interestingly now, you can just look at the notice and you can just tick it off. Right? It's going to be the easy thing to do from now on. So you can tell whether the notice is valid or not. Has the correct form been used? You've got to use the prescribed form for the type of contract you've got. Landlords have got to use the right one. Right? Otherwise, it is not valid. Have the grounds been pleaded and particularized? No use saying, you know, there's antisocial behavior. You've got to say what it is. What's the issue? Plead it, particularize it. Have the grounds been proven? Have they been made out? And then finally, you know, is it reasonable to grant possession? The court will decide that. Is there retaliatory eviction potentially?